Let's talk about intestate laws. This is when a person dies without a will. State law is going to regulate how the property gets distributed. Intestate laws, in theory, they're supposed to be based on what most people would prefer, but honestly, in practice, that's not what happens. Like, for example, most married people leave all their assets to the surviving spouse, but intestate laws do not do that. There's some distribution to spouse, some to children, some to grandchildren. Very few people would want their property to go to a grandchild over a spouse, but these are some of the kind of hurdles, but it try. I think New York does a good job in the intestate laws, and I'll go through that at the end. So let's talk about the order. Intestate laws specify the order in which heirs of an intestate share is going to receive in the estate. So first off, the debts. The debts have to be paid first. The debts of the testator get paid first. Then if there's anything remaining, the remaining pass to surviving spouse and the children. When there is no spouse or children, grandchildren, parents, siblings are the next in line of the decedent. If there's none of these, then there's the collateral heirs, nieces, nephews, aunts, and uncles of the decedent. And if no surviving relatives in those groups, then the property is going to be distributed to the next of kin, which usually comes from any of the collateral heirs. We're looking at maybe children of the nieces and nephews, for instance. Point I want to make, stepchildren are not considered kin. And this is a big issue today because we have lots of second marriages and merged families. And one of the things that I see a lot is folks come to me to do their wills, spouses, let's say a couple, they've been married a long, 10, 15 years, but it's their second marriage, and they both have children from other marriages. They want to make their wills, and they want to leave their property to each other, right? If I die, my spouse gets it. If I die, my spouse gets it. But what happens is, if you set it up that way, and one of the spouses die, and the property, everything goes to the other spouse, then when that spouse dies, everything goes to that spouse's children. The other spouse's children don't get anything. So you kind of leave people out that you may not intend to leave out because of this. Legally adopted children are lawful heirs of their adopted parents. And then the overall, if there's nobody, no next of kin, there's no family basically to get the property, the state is going to assume ownership of the property of the person who died. So how the division works, if we have a surviving spouse and we have children, spouse will get one half if there is one child, who will then get the other half. If there is more than one child, the spouse is going to get a third, and the rest will go to the children in equal portions. So that's if we have somebody who dies without their will, and they have a surviving spouse and children. That's how it will be distributed under intestate laws, generally. Each state has something a little different on this, and I'll show you New York's in a second. Grandchildren, they are considered issue, like I said, a direct descendant, and their distribution to grandchildren is a little different. This comes into play when the decedent had children or one child and they predeceased the decedent. And there's two methods on distribution up to the grandchildren. One we call per stirpes and the other one we call per capita. So per stirpes, and I'm sorry that this is a very big slide with a lot of information, but really it's the easiest way for me to be able to take you through the division. So per stirpes, this takes the share that the deceased parent would have inherited had the parent lived. So the grandchildren are stepping into the parents' shoes. And if we have one grandchild, they take all. More than one grandchild, they are going to split the share equally. This is the version New York recognizes. So if there are surviving children of the decedent, the grandchildren only takes their deceased parents' share. So if a parent is still alive, those grandchildren don't take anything. So let's put it into this example. So we have a decedent. They lived a long life. Let's say they die at 101. Then they don't have a will. And during this life, this decedent, he married, had 2 children. His spouse and 2 children predeceased him. Both of his children had children, giving the decedent grandchildren. One of the decedent's children had 2 children, and the other one had 3 children. So all the decedent's grandchildren are living. And now we're going to use intestate laws and the Persterpe's method of distribution. And here's how it would work. The decedent's estate would be divided into 2 shares, one representing each of decedent's deceased children. The grandchildren would step into the shoes of their deceased parent. So 2 grandchildren would split the portion that would have been their parents' share equally in half. And then the 3 grandchildren would split the portion that would have been their parents' share into thirds. And that's how the Persterpe's method works. They think of it as the grandchildren are stepping in the shoes of the child and splitting that particular share that child would have gotten from the decedent had they survived. So let's talk about the next one. The per capita method. Each person in a class or group takes an equal share. So all grandchildren split the share even if one deceased parent had 2 kids and the other one only had 1 or had 3. So let's use the same example. Decedent lived a long life, dies at 101 without a will. During his life, he married, had 2 children. His spouse and 2 children predeceased him. Both of his children had children, given the decedent grandchildren. One of the decedent's children had 2 children, the other one had 3. All of the grandchildren are living, and using intestate laws and per capita method, what's our distribution going to be? Well, the decedent's estate would be divided among the grandchildren equally. They wouldn't first split between parents, between the child, and then stepping in the shoes. They would just eliminate the parents. They'd be like, okay, here's the estate, here's grandchildren, we have 5, you're going to split it equally. That's how the per capita method works. In New York State, like I said, they use the Persterpe's method, but for purposes of intestate laws, here's how the distribution would go in New York if somebody died without a will. So if the decedent had a spouse and no children, the spouse inherits everything. If the decedent had children but no spouse, the children would inherit everything. If the decedent has a spouse and children, the spouse inherits the first $50,000 plus half of the balance. So, and then the children would inherit everything else. So in New York, they do a different kind of, slightly different split than what I had mentioned a little earlier, but it still goes to spouse and children. If the decedent has parents, but no spouse or no children, the parents inherit everything. If the decedent has siblings, but no spouse, children, or parents, the siblings inherit everything. This was the Prince example. If the child dies before the decedent and the children of their own, and had children of their own, then the decedent would have grandchildren. Like I explained, the Persterpe's method, those grandchildren would step into the decedent's child's place and inherit in place of the child. That's how it would work in the state of New York. I won't take you through the whole rest of cousins and nieces and all of that, but nonetheless, that is generally where the cutoffs usually happen. You get to at least siblings. But if you didn't have any siblings, then you're looking at the collateral heirs. So that ends the discussion on wills. Next up, we're going to talk about trusts.